Hi, everybody. Hey, Olap. I'm excited to see you, Olap. I hope you guys are having a good afternoon. Um, as usual, I'm just here studying. Today I'm working on partnerships and corporations, and that's what we're going to start with today. Okay. Hopefully, I'm sure that eventually these streams will become more fun, but bar studying, sometimes it's just a drag. I've already been doing it for like 4 hours already today, and tomorrow is a bunch of essay writing. So just a lot. But hi, Olap. I'm glad to see you here. I'm basically just spending time waiting till the 4 o'clock premiere. Okay, so let's go over partnerships. Okay, so a partnership is, and I'm just gonna write P-ship because that's shorter. Association of two or more people. And if you're here joining, feel free to say hi in the chat. Feel free to ask me any questions about law school or studying for the bar, or just to say hi. So partnership is an association of two or more people with the intent to carry on for-profit business. Okay. So two or more people intending to do business. Okay. A person, I don't need that. I wonder if I should just go to corporations. No. Okay. Some of the stuff, the reason I'm like going is because some stuff is just so repetitive that it's like, do I need to write this down twice? But okay. The key to a partnership is sharing profits. That's the key. If you're sharing profits with somebody, you are in a partnership. And if you don't want to be in a partnership, you're going to have to fight it. Hi, everyone joining. Feel free to say hi in the chat. Okay. Now, there's some times where you do share profits and it's not a partnership. Not partnership. Okay. If you... The sharing of profits... Oh. Okay, I got that completely backwards. So, sharing profits creates a rebuttable presumption of a partnership. And what that means, a rebuttable presumption that that shows up in like all areas of law. It means this is like the default, and then if you want it, so that's the assumption, and if you want that to be wrong, you have to prove it. So for example, if I was to open up like a lemonade stand with somebody and we went to court would just tell us your partnership. That's the assumption. And then I could rebut it with evidence and say, no, we're not partnership. Hey, the W. Thanks so much for your luck. I definitely need it. Okay. So if you share profits, you're assumed to be in a partnership, but you can rebut that. Now, in some states, there are 6 situations where you are always going to be a partner. It is not What is it saying? Does not create a rebuttable presumption. Does the range? Okay. Wait. Sorry, I know there's a lot of dead air. Okay. I might just switch to corporations because I think, yeah. Okay. So let me go to corporations because that's, I'll come back and do that. Okay, this would be much easier. Okay, so let's learn about corporations. Okay, so, um, so to form a corporation, um, there may be a promoter. So a promoter is someone who raises funds and gets is created. Um, a promoter raises funds and enters into contracts. Okay. So who's responsible for what happens before you become a corporation? The promoter. And is liable for pre-incorporation activities. Um, do do do. Okay. To establish liability, it is insufficient that a person should have known that the corporation was not formed. Okay. So promoter to be liable, the promoter must know the corporation hasn't been formed yet. If they don't know it, if they think that it is a corporation, I mean, that's basic contract law, but if they think it is a corporation, then they're not going to be responsible. Alrighty. Promoter has a fiduciary duty. Oh my gosh, can't even spell fiduciary relationship with the pre-incorporated corporation. Okay. La 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 la. All right, I'm going to skip past this because this is boring me. Let's go on to how you create a corporation. Okay, so to form a corporation, you have to file, yeah, this must file articles of incorporation with the state. Okay. These include basic information like the name, the shares, the purpose, the powers, and the okay, basic info. And importantly, the company name has to include the word corporation. Well, name must include either corporation, company, incorporated, limited, or an abbreviation. Okay. So it has to have corporation, company, limited. What the heck was the other one? Corporation, company, limited, incorporated. Yeah. Okay. The articles must include the purpose. And I'm not gonna worry about that. Okay. The articles have to be filed with the state official, usually with the Secretary of State, and a filing fee paid. Okay. So the corporation exists on the day when the articles are filed, unless the articles give another date. Or state has different rules. So some states that you might file, but you might not actually be a corporation until they get to look at it. Doesn't matter right now. Okay. So the corporation can do certain activities that are within the business purpose. So when they file the articles of incorporation, they have to put the company purpose. If they start doing things that are outside of the company's purpose, that has a special name. Activities outside the company's purpose are called ultra vires acts. Okay. Activities outside company's narrow purpose. So ultra vires acts apply to narrow purposes, and you'll hear like narrow being talked about in law, and that just means like really specific. So if a company has a very specific purpose and they start doing things outside of it, it's called ultra vires. Okay. So apparently most states why would you want to stop someone from doing this? Okay, well, anyway, some things that can happen once a company starts doing these activities outside of its purpose. A shareholder can enjoin. And enjoin means like stop. Stop the act. The corporation can take action against the individual who did the act, or the state can enjoin the act. Okay. I have feelings this doesn't, I don't feel like this is going to come up on the test. Well, I should never ever say that. That's not true. I feel like it's not going to be a big part. All right. And the shareholder can enjoin the act only if it is equitable, which just means fair. Okay. Whatever that means. Enjoin is hey CH, I'm so happy to see you. Enjoin is a weird word and it doesn't mean at all what you would think it would mean. Yeah, I've learned my vocabulary is all sorts of messed up because of law school, I swear. I was saying earlier that I'm literally just like spending the next half hour waiting until OLAP's 4 o'clock premiere, which I'm super excited for. Okay. Um, Sorry, I'm not gonna worry about that. All right, so oh, this is so difficult. They make this so confusing. Okay, so what happens when you have filed and the what happens when you have filed? Okay. So incorporation, which just means the creation of a corporation. Creation of a corporation, yeah. Okay. Once state requirements m- m- met, it is called a de jure corporation, which just means what it means, what it says. Now you can have a defective incorporation. So I'm guessing this is a successful incorporation. Okay, so you successfully incorporate, you have what is called a de jure corporation. Now what happens, and that means that the corporation is responsible, not the people. I should actually probably write that. That means the corp is liable. Okay. So what happens when you have defective incorporation? So if you are conducting business as a corporation, um, I know de jure does sound fancy. It made me think of soup. Like I feel like that's like soup of the day or like soup de jure. I don't know if that's right. It sounds like it. Even though I think that's Latin. This is Latin, I'm sure, and that's French. Um, a de jure corporation. Yeah, CH. That's exactly what I was thinking of. That's really funny. Yeah, that's exactly what I was just thinking of. Um, okay, so if you conduct business as a corporation and you do not even try to meet the state requirements, then you will be personally liable for whatever happens. Which, I mean, I guess that makes sense. If you don't make an incorporation, you're going to be liable. So I'm not going to write that down. But if a person does try to incorporate, then they might not be. And I think that's the important part. If you make a good faith attempt to incorporate, like meeting the state requirements, you um, might escape personal liability. Okay. Through two ways. One, de facto corp, or two, corp by estoppel. Okay. So if you try to be a business, but you do not, or if you run as a business, but you do not try to incorporate, then you're personally liable. If you run as a business or act as a business and you try but fail, you might be okay under these two doctrines. Okay, so what's de facto corp? Which de facto I already know means like it exists but not officially. So de facto corporation is yeah, de facto corp is business entity that made good faith effort to incorporate, and they are treated as a corporation. Oh, and you have to not know. I did not know that. And believe they are a corporation. They should not hide that. That's an important part. Okay. So if you believe you're actually a corporation, and so if you think you met the requirements but you didn't, you might still be okay. Um, okay, that's easy. Now, if you court by I love this. Court by estoppel. Is that like putting a cork in a champagne bottle? I love that. I think the first time I thought I saw estoppel, I could thought of it reminded me of like something religious. Like it reminded me like of steeple or something like that, maybe. Um, it's so silly. Estoppel just literally means like stopped, to stop something. So, um, and in fact, here it really just means you're you're stopped you're stopped from arguing something. That's what it means. Um, so if you contract with a business and you think it's a corporation, you don't get to sue the person individually if they thought they were a corporation. So it's just the same thing. Lord, it's not the same thing, but so corporation by estoppel. Um, if you think they're they if you think it's a corporation and enter contract, treated as a corporate, well, let me put this, no personal responsibility if corp made good faith effort and was not aware of deficiency. Ooh, that was clunky. Okay, but now I'm gonna say what I just wrote down. So, to incorporate, you have to file your articles of incorporation and meet the state requirements. Once the state requirements are successfully met, you become a soup de jure corporation. And the de jure part means that, well, that's not what it means, but what it signifies is that um, no longer is it like a group of the people aren't responsible. Now there's a corporation that's responsible for the business activities. That's a de jure corporation. Um, if you don't try to comply and incorporate, but you still act like a corporation, then you're responsible if you know you're not. But if you try to incorporate and you think you're a corporation, you can be treated as one in two situations. The first situation, which is basically the same as the second, but the first situation um, is when you're operating in a de facto corporation, which just means the business is operating as a corporation. You've made a good faith attempt to comply, and you believe you have complied. If you know you have not complied, you are not de facto. And secondly, if someone contracts with a business and that person thinks they're a corporation and the business owner thinks they're a corporation, then the corporation is responsible. You can't, the business owner isn't responsible for their mistake, which is also annoying because this is basic contract law. Because in basic contract law in general, like if you have like if you have if there's a mistake and there's no reason for you to have known or should have known, or if it's reasonable for you to not have known, um, you might not be responsible. So yeah, if you're a business owner and you think you are a corporation, then okay. I'm not sure how much sense that made, but okay, so let's talk about stock. Gosh, I tried to take corporations in law school, and people say you should take corporations in law school, but I just couldn't. Like, I think 3 semesters I added it to my schedule, and I sat down and I was like, I can't do this class. It was just so boring, and it felt like it was like a different language, and I was like, I tried 3 different professors, and I could not do it. Good. Okay, I'm glad to know that, CH. That's a good sign. Okay. Um, so let's talk about stock and securities, which I'll find out what that is. I mean, I do know it has to do with money. Okay. Um, every corporation is required. Oh, okay. This part I know. Every corporation is required to have stock and voting stock and, oh, I'm sorry for that loud noise. Okay, so every corporation, boring, but that is where the money is. Cost my family thousands to set up a trust. I bet. And that's the hardest thing too. It's so boring, but that is where the money is. And I actually think if you go to law school, probably one of the smartest things you could probably do is learn where the money is kept. um, for sure. I had an Australian professor, and his accent kept distracting me. The last time I tried my last year of law school, I tried his Australian accent just kept distracting me, and I couldn't understand what he was saying either. And they do cold calls in law school, where they just like you have to read, and then the professor calls on you the next day, and you just like pray you know the answer. And his cold calls were so hard for me because I couldn't understand what he was saying. So I chickened out and like I was like, I can't take this class. Um, every corporation has to have stock. Um, there's common stock, which is represents voting rights and ownership interests. And then there is preferred stock. I'm actually excited for this because I've gotten pieces of corporations from other classes I've done. Um, but I'm excited for this. And I think after this I have constitutional law, and that's gonna be rough. Oh boy. So preferred stock um is exactly what it sounds. Stock that has preference over other types of stock. Okay. Um to All right, I'm gonna keep going. So issuance of stock has to be authorized by the board of directors. Um, or okay, stock must be issued by board of directors or shareholders if the state allows. Okay. Okay. Restrictions on type of consideration. Okay. So now we're going to talk about consideration. And consideration in contract and business law means um, basically like a payment that you give. So the law doesn't like contracts where only one person is making a promise. So idea of consideration is to make sure that either like both people are getting a benefit or one person is giving up something to gain something. Consideration is just making sure that there's actually like a deal happening. If you're here from Jolene and you're thinking about like Trisha and Beth B, I think she said like she and Beth B have a deal, and I always was wondering like what did what did Beth B gain from this deal? I don't think as Trisha gave up much for gaining from Beth B. Um, anyway, so you have to also give consideration when you're getting stock because stock is issued through contracts and contracts require consideration. You just need some friends from the north of Scotland. Once you can understand them, you can understand any accent except those from West Birmingham. Oh my gosh, I really do have the worst times with accents from like from Scotland specifically. Um, but I love that. Hey, and I just saw a video of the Scots marching in Boston because of the World Cup. That looked actually really fun. Except those from worst of Birmingham. That's so funny. The Tartan Army. Yeah. Um, it looked really cool. It looked really cool. CH, are you in Scotland? Are you well, you don't have to dox yourself, but are you in the US? Um, where was I? Okay, issuing stocks. So, consideration. You have to have some consideration to get stock. That can be money, property, or services. Okay, can exchange money, property, or services in exchange. Um, when the corporation receives the consideration, it's deemed fully paid, and a shareholder who fails to pay. Okay, Bob, I'm just going to write that it requires consideration because it's telling me that if someone does not give up something for the stock, then it can be completely canceled. The board of directors must determine that the consideration. Yeah, all right, got it. What? All right, other types of stock. So there's common stock, there's preferred stock. There is also par value stock. It's not required. Well, optional stock. Oh my gosh, sorry guys. I keep going down rabbit holes, but that's because my outline is taking me down rabbit holes that I don't need to go down right now. Okay. All right, I'm not going to go over that. Let's talk about shareholders' rights. Okay, so shareholders have preemptive rights, which allow you to purchase new shares to maintain ownership percentage. Okay, so as the company makes more and more money, you're going to want to grow your, like, if you are going to own, like, you're going to want to, as the company grows, you're going to want to continue adding shares so your ownership does not go down. So as other people are buying, we'll see what this means. So let's see this example. So if two people own 50 shares of stock, and then the corporation issues another 20 shares. A and B, okay, that's what I thought. A and B can each purchase half of those shares to make sure they keep half of the company. All right. Oh, is it saying they are the first ones who get the option to purchase? Okay, so preemptive rights have to be included in must be included in articles of incorporation. No preemptive rights does not apply to stock issued as compensation, authorized in the articles, and issued within 6 months of incorporation, or sold for something other than money. Okay. Hey, Andy. Oh, it's so good to see you. I was just telling Olap that I'm here just wasting time until the 4 o'clock premiere. Oh, I have a lot to catch up on. CH, the Black Country is the industrialized area west of Birmingham, and honestly, one of the most impossible accents to understand. Not in Scotland, have lots of Scottish friends. I love that. I honestly have the worst times with English accents and Australian accents. I swear every other accent I can understand, but I need to put myself to the challenge with those ones. Beef stock, chicken stock, there's a lot of stock going on. And they kept adding new types of stock after I thought I understood all the types. The W, I'm not in a study group, but at least not right now. But I live near my law school and I have friends who are still in the same city. And so, like, our law school has lunches for us. So we'll meet up at the law school and study and cry together. Hey, Chelsea, I just did a discovery case on a corp stock holding lawsuit with other shareholders. I wonder, well, the discovery for that type of stuff is actually kind of interesting. So I hope it wasn't terribly boring. I like doing discovery. It's the best way to just go through emails and see the weird things people say. Alrighty, so preemptive rights are rights the shareholders have to purchase. Oh, well, it went all the way back to 1964. Never mind, I take that back. That is way too much discovery. Oh, oh my gosh. That's too much. So you can buy shares to maintain your ownership percentage. And it does not apply and it has to be, preemptive rights have to be provided for in the articles. At common law, they used to be automatically granted, but now the reformed, the Partnership Act doesn't allow for them unless they're in the Articles of Corporation. That's all I need to know. And it doesn't apply to stock that is issued as compensation or stock that was authorized within the Articles of Incorporation within 6 months of the effective date of incorporation, nor does it apply to stock that is issued in exchange for something that is not money. Hey, all right, so I think I got that. I was in archives and digital. That was such a great hunt. Oh, that would be fun. Okay. That actually would be fun if you're working there. If you were having to work with like anything paper, oh, it's too much. Or like, or rather, I should say, organizing the paper. Okay. Federal restrictions on securities. So if you're issuing stock, you have to issue stock, then you may have to require, okay, issue stock, may have to register under the SEC. I don't like writing that because I want to know when you have to register, when you do not. So public offerings, registration is required. That's what I thought. Required for only for public offerings. So offering stock, public must register SEC. Okay. The purchaser of a security for a corporation. Okay, so if you buy stock from a company that has not registered, you can sue to get your or to cancel the stock. I mean, that just seems like basic contract law again. Additionally, the purchaser, blah, 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 blah. Sorry, guys. Okay. Let's talk about distributions. So, which is the transfer of cash or other property from the corp to one or more shareholders. Okay, the most common type of distribution is the dividend, which is normally a cash payment. Yeah. Okay. So the power to authorize distributions is with the board of directors. Board of directors cannot make distributions if it's insolvent, which is basically like bankrupt or soon to be bankrupt. Or if would cause insolvency. Okay. So you cannot start, I think I knew that. You cannot start paying out money to your shareholders if your corporation is going to go under. Or if paying the money would cause the corporation to go under. Okay. So what does it mean to be solvent? So the solvency test, two tests that corporation has to pass. The equity and the balance sheet tests. Okay, so the equity test for solvency, the corporation has to be able to pay its debts on time. Okay. Corp must be able to pay debts on time. right, the balance sheet test. The corporation's total assets must be more than what it owes, plus must exceed its, okay, so total assets must be greater than liabilities, so things that it owes, plus liquidation preferences. And liquidation preferences means like turning the stock into cash. Okay. Solvents. So for dividends, solvency is measured when dividend is declared. For stock purchases, solvency is measured on the date purchase, on the date payment is made. Okay. If a director votes for unlawful distributions, or so that means unlawful payments from the company to shareholders, they can be individually responsible for the extra amount. Okay. So, unlawful dividend, which I'm assuming I'm going to learn what an unlawful, what type of dividends are unlawful, but I'm going to take that back. An unlawful dividend would be one where you pay it when the corporation is insolvent or will go insolvent. So I guess I already knew that. If director voted, personally liable for the extra amounts. So if like they were only supposed to pay a dividend of 100, but the director voted for 200, the director would only be liable for the 100 extra. Okay. Oh, it's so close to 4. I'm going to head over to OLAP soon. A director, okay, yes, that makes sense. And if a shareholder accepts knowingly accepts an unlawful dividend, then the director is entitled to take it back, basically. Okay. The right to compel a dividend you have to prove 2 things. So to sue, suit to compel dividend distribution, you have to prove funds are legally available, and to directors' bad faith refusal to pay. Okay. What about outstanding stock? Outstanding stock. That's authorized and issued Okay, I'm gonna have to come back to that. Okay, I'm gonna take a break. My brain is fried. Thanks, guys, for hanging out with me. Chelsea, this is where it's just fun. This is where I gave up, Chelsea. That's so funny that you said that, Chelsea. Yeah, this is where I'm like, I need a break. But I'll probably be on later and then I'll pick back up with this. So feel free to come and hang out again. But thanks guys for hanging out with me. I will see you guys probably later today. But have a good break. Bye. I'm all up in this corporate stuff. I need to channel my inner Chelsea then. Bye guys.